Hello and welcome. I am Bhavin and you have tuned into the 9th episode of the Law and Tech Bulletin from Lawyers Learn, a show where we bring you the latest from the law and technology space. Here's what made headlines in the last fortnight. The Supreme Court will soon be included in the National Judicial Data Grid. This means that all Apex Court orders rendered since its establishment in 1950 will soon be available over the National Judicial Data Grid, along with statistics on case pendency, disposal, and filing details. The Supreme Court will also be accessible on the eCourts mobile application, which previously only provided access to district courts and high courts. More from the Supreme Court. In a bid to increase transparency and accessibility, the Apex Court has decided to live stream the proceedings of all Constitution Bench hearings from the 27th of September. The decision was taken unanimously by 30 judges of the Supreme Court at a meeting headed by Chief Justice U. Lalit. In 2018, the court had ruled in favor of live streaming, as per citizens' rights under Article 21 of the Constitution. However, that verdict remained to be implemented. The Madhya Pradesh High Court has opposed a petition before the Supreme Court that seeks to declare virtual hearing as a fundamental right. The High Court has argued that the existence of infrastructure does not confer an automatic right on lawyers to argue through virtual modes. In this case, the petitioner had argued that the denial of access to hearing through virtual mode is akin to denial of fundamental rights under Articles 19 and 21 of the Constitution. Supreme Court Judge Justice D.Y. Chandrachud has expressed concerns over social media users failing to differentiate between oral remarks made by judges during court proceedings and the actual order. Justice Chandrachud clarified that such remarks were merely dialogues during hearings and were meant to open up channels of deliberation. He also emphasized that such observations could be corrected by lawyers as well, and added that they must not be treated as verdicts. The Ministry of Home Affairs has notified the Criminal Procedure Identification Rules of 2022. The new law, cleared by Parliament earlier this year, has repealed the Identification of Prisoners Act and has increased the powers of law enforcement agencies and courts to process biometrics, DNA samples, etc. of criminal offenders. The law has been challenged in different high courts on concerns regarding collection of biometric data, especially in the absence of a data protection law. And now, the big appointment buzz of the fortnight. Senior Advocate Mukul Rohatgi is likely to return as the Attorney General of India. According to reports, he is expected to succeed K.K. Venugopal when the latter demits office as the 15th Attorney General of India on the 30th of September. This will be Mukul Rohatgi's second stint as AG after his first stint between June 2014 and June 2017. Those were the big stories for this fortnight. Our podcast is available across all major platforms: Spotify, Google Podcasts, Apple Podcasts, Amazon Music, and Anchor. Do subscribe wherever you get your podcasts. You can also tune in to this bulletin on YouTube. Please also share your feedback to help us make this bulletin better and more useful for you. See you soon with the next installment of the Law and Tech Bulletin from Lawyers Learn. Until then, toodaloo.